Hey, Dan. Not sure if this is live. Is this live? Oh, it's live. Get rolling, shall we? Huh? Well, when I give my opening remarks, probably when I give remarks. Perhaps I'm on another stance. This is the way I should go, but I just sort of feel more comfortable standing. Gives me a direction for my energy. Hey. Hey. All right.
Nice to see you. Yeah.
I think we've been at conferences. Yeah, I think that's right.
Hi, nice to see you. We met briefly, I think at Stanford last year.
Yeah.
Maybe someplace else, but it's nice to see you again. And thank you for your wonderful amicus brief and the article in Virginia.
I don't know whether helping or hurting.
Oh, I think it helps tremendously, and I quote it. The argument's next Wednesday.
Yeah, I know. Have you mooted? Are you?
I did one.
All right, welcome everyone. How's this microphone? Thanks for hanging around till Friday afternoon. I hope my colleagues and I, boy, it feels like I'm amplified in a strange way. Is this a little echoey? What would happen if I just did this? Can people hear me? Or this? This seems better. Yeah, thanks for hanging around to Friday afternoon. I hope the four of us can say enough controversial and taboo things to make it worth your time, entertain you a little bit. We got this remarkably distinguished set of speakers. We'd have still more so if Erin O'Hara O'Connor, the Dean of Florida State College of Law, could have been with us today. Unfortunately, she had to cancel. I don't want to take too much time before getting to those substantive presentations, but I do want to say a few words at the outset about the ideas at the genesis of this panel. Today's panel is an effort to think about the resurgent culture wars in the academy from a new perspective. Perhaps the most familiar perspective has to do with free speech. So conceived, the central issue facing universities on these matters is whether and to what extent they should open or close their doors to certain highly controversial ideas or speakers. So in that debate, one side flies the banners of free speech. Others argue that certain claims, certain kinds of speech are beyond the pale of decency or so offensive as to constitute harm. And the opposition, the sort of thesis antithesis, to use Hegelian terminology, is free speech versus social justice, and the two sides are joined. Well, this framework has much to recommend it. The right to free speech is both part of our legal constitution and part of our broader political culture. That makes the free speech formulation accessible. It's sort of ready for use in public discourse. It's part of the furniture of American political culture. Even the verbal form free speech becomes a sort of vase into which to pour a variety of different ideas, some closer to and some farther from the legal structure of the constitutional right to free speech. But the free speech framework also has certain limitations. First, one is that universities limit free speech in all sorts of ways, largely for reasons of quality. It's not, for example, the case that every physics department needs to have an astrologist on staff or needs to welcome speakers on astrology. In that sense, it's obvious that absolute free speech does not quite get at the issue. There might be distinctions, of course, between poorly reasoned ideas like astrology and carefully reasoned but heterodox ideas about politics. Nonetheless, it's difficult to maintain those distinctions in practice. Second, and I think less obviously, when the issue is cast as one of free speech, the structure of the debate goes in an unproductive direction. One's position in the debate becomes just a function of how strongly one believes in free speech or how strongly one believes in social justice. So consider some of the hot button issues and the line drawing questions they raise. Anti-abortion ideas, opposition to homosexual marriage and related issues of sexual identity, affirmative action and related issues of race, current controversies about immigration. Look at these issues from the standpoint of someone who sincerely and strongly believes in promoting social justice on campus. So long as the structure of the debate is free speech versus social justice, the question facing such a person is simply, how strong is your commitment to social justice? The more you care about social justice, the less tolerant you should be of anti-social justice ideas. We've seen this structure before in the paradoxes facing ideas of toleration in early modern Europe. For devout Christians faced with resident Jews and Muslims, the question was, how much should we tolerate that which is, by assumption, wrong or bad or evil? And the obvious response, it's not the sole response, but the obvious one was, the more sincerely and devoutly you believe in Christian ideas, the less tolerant you should be of anti-Christian ideas. And so one's toleration became a measure of one's piety. I don't think that's a productive direction for the debate. Now, in saying all this, I don't mean to denigrate the free speech framework. I think it's an important part of thinking about the present culture wars, but I do dispute that it is the sole issue, and perhaps that it is the central issue. Another standard framework for thinking about these issues is in terms of intellectual diversity, and this too has much to recommend it. Diversity has become a hallmark value in university culture, and conservatives and libertarians have been quick to point out that diversity includes intellectual and political diversity, which means airing heterodox ideas about hot-button political issues. And this too is a helpful framework, and like free speech, I don't mean to denigrate it. In fact, in my substantive remarks later, I'll return to it. But the diversity framework recapitulates many of the problems facing the free speech framework. First is the problem of diversity versus quality. I mean, surely diversity can't mean that we should have, again, an astrologist in the physics department or a Wiccan in the medical school or something like that. Second is the problem of diversity versus justice. From the perspective of a true believer, the question of diversity is why and to what extent should we tolerate professors or students or guests of the university whose ideas are just wrong or just bad or just evil or just offensive. So my goal in creating this panel is to put on the table an alternative framework with which to think about these issues. My proposal is that a central issue in the current culture wars on campus, the sort of thesis, antithesis, or organizing opposition, is about political orthodoxy on the one hand and scholarly rigor on the other. The value of scholarly rigor occupies a unique place in the academic world. To be a scholar is to be someone whose profession it is to produce and evaluate ideas. Scholarly rigor is the label we use today for engaging skillfully in that activity of idea production and evaluation. It used to just be called reason. We call it scholarly rigor now. There's a striking, even haunting line in John Rawls's theory of justice, where he says, justice is the first virtue of social institutions as truth is of systems of thought. A theory must be rejected or revised if it is untrue. Likewise, laws and institutions must be reformed or abolished if they are unjust. The virtue we call scholarly rigor is the first virtue of scholarship in that same Rawlsian sense. If it were the case that a certain social organization of the university prevented or diminished scholarly rigor, that would be, I submit, a fatal and dispositive reason to reform that part of the university's social structure. I mean, if it were the case, say, that every important discovery in physics took place outside the confines of university physics departments, so no serious talented young physicists sought a career in academia, that would be a fatal objection to university physics departments. That's the Rawlsian first virtue principle. Yet there have been times historically in which universities or university of departments have become lifeless in that Rawlsian sense, times when everything worth doing took place outside the university walls. It's striking how few, for example, of the major political theorists of the English Enlightenment and counter-Enlightenment were university professors. Thomas Hobbes, John Locke, David Hume, Edmund Burke, Jeremy Bentham, John Stuart Mill, 300 years of intellectual life in English political theory and not a single university professorship among them. I became puzzled enough by this phenomenon to look into what was going on at Oxford's and Cambridge's philosophy departments during that 300 years. And as far as I can tell, this is tentative, but as far as I can tell, the professors there were engaged in various forms of theological and Aristotelian scholasticism that had its home in medieval era. They just missed the Enlightenment. The birth of the modern state and the birth of modern science went by those philosophy departments. So the genesis of this panel was a set of discussions that made me realize that my misgivings about the political orthodoxies and taboos of the present moment are not centrally about free speech and not centrally about diversity, but about high-quality scholarship. In dark moments, this is not all moments, but some moments, it seems to me that academic culture at present impedes and inhibits thinking carefully and rigorously about the social world. It's such that, again, someone who is a serious-minded person seeking an understanding of the social world would locate himself or herself in, I don't know, a think tank or a journalism or anywhere but the university. In those dark moments, the modern university strikes me as a world of orthodoxies and taboos and denunciations that interfere with the very process of creating ideas, evaluating evidence and arguments, considering and responding to doubts, that with all the things that make scholarship scholarship. But those are the dark moments, and there are good objections to that polemical view. For one thing, not all orthodoxies are political. Intellectual orthodoxies are part of any field. Intellectual disciplines require to share premises about what constitutes sound methodology, for example, just in order to get the scholarly inquiry off the ground. Furthermore, not all political orthodoxies are of the culture war variety. Consider the many Christian universities that insist upon creedal commitments in their own inquiries, that train students to ask, what is a Christian reading of Othello, or what is a Christian position on international monetary policy? Why shouldn't other universities ask, what is a left position on Othello? What is a left position on international monetary policies? And furthermore, as those Christian universities illustrate, academia is not as monolithic as it might seem. Taking all these considerations into account, I want to close by suggesting three thoughts. First, that the question of scholarly rigor versus political or intellectual orthodoxy is a fruitful one. The antipode or opposition, or thesis-antithesis structure, orthodoxy versus rigor rather than orthodoxy versus free speech or orthodoxy versus diversity, is just a valuable lens with which to think about these issues. And I think, insofar as conferences like the present one are good opportunities to put ideas on the scholarly agenda, this is one I'd like to put on the scholarly agenda. Second, the dark thesis I suggested earlier might be true. It might be that the central problem of contemporary university culture is that political orthodoxy suppresses rigor. I think that's worth discussing. And third, that dark thesis might be false and should not be treated as self-evident, should be discussed and evaluated. And it's in that spirit that I sponsored the development of this panel and now turn it over to Tom Lee to lead the moderator.
Okay, so I'm going to be a navigator through this, and I'm going to be very succinct. I'm going to introduce our speakers and then guide some questions, but leave the floor mostly to them. So to my right, we have Professor and Dean Erwin Chemerinsky of the University of California, Berkeley School of Law. To his immediate right, Josh Kleinfeld of Northwestern University Law School, and to his right, Will Baude of the University of Chicago. And we'll proceed in that order. Each speaker will have 12 to 15 minutes, and then I will frame some questions for another 12 to 15 minutes, and then open up the floor to questions. And again, we're sorry that Erin O'Connor couldn't make it today. She would have been the next speaker, but without further ado, Dean Chemerinsky.
Thank you so much. It's really an honor and pleasure to be part of this panel, and I was especially pleased when I saw the title of it in the WLS program. It says, A Conversation for Young and Nearly Young Law Professors. I like being able to think of myself as a young or nearly young law professor. This afternoon, I want to defend freedom of speech, intellectual diversity, and intellectual rigor. I don't believe there's any tension among these concepts. In fact, I believe they're very much reinforcing. My ideal of a law school, and as a law professor and a law school dean, that's what I want to focus on, is that you're a place where all ideas can be expressed and discussed. I want to have a faculty and a student body that's diverse in every way, including intellectually diverse. At the same time, of course, I believe in quality of scholarship, quality of teaching. I think that's what we mean when we're speaking of intellectually rigor. I think we can evaluate ideas, we can evaluate teaching, we can evaluate scholarship, even though we may have disagreements. I do not see a lack of either rigor in the current law schools or of intellectual diversity. I do not see orthodoxy as a threat to that in any way. Now, in order to achieve the goals that I've said, there are challenges that we have to recognize. So I thought what I would do is talk about what I see as some of the challenges that we face in achieving the goals that I've described, and then some of the solutions that I would propose. One challenge we have to recognize is that legal scholarship is often normative. And I think that's a good thing about legal scholarship. We're helping to improve the law and society, whatever our viewpoint. Rigor and quality are difficult when what we're doing is evaluating normative scholarship. It's not like we can talk about a mathematical proof where we can say there is a right or a wrong answer when we're dealing with normative questions. We can certainly discuss and debate whether originalism is a desirable method of interpretation, or whether diversity is a compelling interest in the classroom, or any of the other issues that come up in constitutional law that are inherently normative. But I think that's true throughout legal education and the law school curriculum. I remember having a discussion many years ago as a young law professor with one of my colleagues who was quite conservative politically, who was identified as doing law and economics. And he said he had a neutral methodology and he just took it to where the results came out. But as I looked at his work, if you start with the assumptions he did, then you'd come to the conclusions he did as well. It's not as if it was really a neutral methodology. It was very much normative. It was just that the normative basis for it was hidden in the assumptions. Second, we have to do content-based evaluations. That when it comes to evaluating student work, when we're reading papers and exams, we're evaluating their content. When we're choosing who to hire, we're looking at the work that they've written. When we're evaluating our colleagues for promotion, for tenure, we're again making content-based evaluations. So as much as there is a mantra that we don't want content-based restriction on speech, of course we're doing content-based evaluations. It's what you say, a physics department doesn't need to have an astrologist. They're making a clear and obvious content-based evaluation. I don't think a history department needs to have a Holocaust denier for the same reason. Then this leads to the third point. There's an inherent danger that our content-based evaluations of normative scholarship might be based on our ideology. It is much easier to agree with that, to praise that which we agree with. It's much harder to praise that which we disagree with. There is always the danger that I, as a professor, might be inclined to give a higher grade to the paper that I agree with than the paper that I disagree with. The same thing with regard to evaluating colleagues' work. That would be inconsistent with the premises that I started with, but it's a real problem. Finally, there is an inherent challenge in ensuring intellectual diversity within law schools. There is a problem with regard to ensuring intellectual diversity on law school faculties. I want a faculty that is ideologically diverse, but in evaluating faculty candidates, I generally can't know their ideology. Now, obviously, if you look at my CV, it's easy to tell what my ideology is. And people who write in certain fields may be easier. But I can honestly say, we just at my law school made 3 entry-level faculty offers. At least for 2 of the 3, I have no idea if they're liberal or conservative, nor would I feel comfortable asking them for the ideology, nor would I feel comfortable as a basis for choosing one person over another to say, I should reject this person on account of his or her ideology. That makes achieving ideological diversity much more difficult than at first it might seem. So with those challenges in mind, what are some of the solutions? I start first with a commitment to freedom of speech and academic freedom. I think we have to begin as academics, whether liberals or conservatives, with saying that a university should be a place where all ideas can be expressed, period. Now, this isn't always popular on university campuses, and it's not always popular within law faculty. There's an incident at the Berkeley campus a year ago this fall. There was anticipated to be a free speech week where Milo Yiannopoulos and Ann Coulter and Steve Bannon were coming, and the chancellor convened a large forum in an auditorium far bigger than this one, and had a few faculty members to speak, and every seat was taken. Every square inch of floor space where somebody could be was taken. And one of the first people to speak was a professor who said that white supremacy is the largest problem in society, and the chancellor should exclude any hateful speakers. And there was resounding applause from the audience. Then in the question and answer period, a student spoke up quite eloquently and said that she felt threatened when there were hateful speakers on campus, and she wanted the chancellor to stand up for the students and protect them and exclude such speakers, no matter what the First Amendment and the courts might say. And there was resounding applause. And then I spoke up as a member of the panel and said, let's be clear. If the chancellor tried to exclude any of these speakers, she would get sued and she would lose. That when Auburn University tried to exclude the white supremacist Richard Spencer, he and his supporters sued, and they won. I said the university would have to pay attorney's fees. I said it's possible even that the chancellor would be personally liable because she's violating clearly established law. Those excluded would make themselves out to be martyrs and victims. Nothing would be gained because they'd get to speak anyway. No one applauded when I said that. And so I do think it's so important that we constantly reaffirm our commitment to freedom of speech and also to academic freedom, that academic freedom does protect the ability of people to say whatever it is they believe and the ideas that they want to express. Now, you expressed concern over orthodoxy within the academy. I don't share that worry, but I think academic tenure is so crucial to that, that once somebody has tenure, it is the protection that they're going to be able to be as innovative, as challenging as possible. And I think it's very important that we do everything we can to protect tenure in order to be able to protect freedom of speech, in order to be able to protect academic freedom, to avoid the orthodoxy. Second, I think that there has to be a commitment to intellectual rigor, that we have to make quality assessments. That I think it is possible to make quality assessments in a non-ideological way. We must be committed to doing everything we can to make those quality assessments in a non-ideological way. To me, this is what intellectual rigor is about. I can think of works, take John Hart Ely's work, Democracy and Distrust. I think I disagree with everything he says in that book, but I would still tell you it is one of the best written, best reasoned books with regard to law. I disagree with almost everything Alexander Bickel wrote, and yet I can still tell you that I think it's excellent legal scholarship. I use these as examples to say, for all of us, it is possible to divorce our ideology from our assessment of scholarship, our ideology and scholarship. So we can look at things like the quality of the reasoning, the nature of the argument, the accounting of counter-arguments, the quality of the writing, the quality of research in assessing work. We can debate it, but we should always be making that assessment in a non-ideological way. We can also, in a non-ideological way, agree in terms of what counts as scholarship. I, as a law school dean, as a tenured professor, don't believe that op-eds and blog posts count as scholarship. Doesn't matter whether they're liberal or conservative. I don't regard them as scholarship that should play a role in evaluation, promotion, and tenure. We can disagree about that, But to me, it doesn't matter whether it's a liberal or conservative position that's held. To me, that's about defining what we mean by intellectual rigor. And third, I think we need to have a commitment to civil discourse. Now, I don't believe that civil discourse is enforced by law. I can have a set of principles of community for my law school in terms of how I want people to talk to one another. And it's not in tension with the First Amendment, because I'm not going to punish anybody who doesn't adhere to it. But I believe there has been a tremendous erosion of civil discourse in recent years, and I think that's to the detriment of the academy and society. I think it is possible to disagree without being disagreeable. I think that sarcasm, caustic language should have no place in academic discourse or even in political discourse. But I don't think that that's inconsistent with any of the things that we're saying. So in that way, I think you can put all of this together, and though we can't always achieve it, the goal should be freedom of speech, intellectual diversity, intellectual rigor, that those are at the core of what a law school should be about.
Thank you. Josh?
No, thank you. I'd like to venture an argument, a sort of trial balloon of an argument I've been experimenting with. It's an argument as to why political orthodoxy tends to diminish scholarly rigor. It's a theoretical argument. It starts from the premise that there is political orthodoxy, or it hypothesizes a political orthodoxy. But it's an effort to see clearly the mechanism by which political orthodoxy would reduce scholarly rigor. The basic idea is that political orthodoxy undermines the conditions that make scholarly rigor possible. And it's got sort of a syllogistic structure. The first idea, the premise is that scholarly rigor is the first virtue of scholarship in the Rawlsian sense I discussed in my opening remarks. And the second is that scholarly rigor in normatively or even factually oriented examinations of social life can't be accomplished algorithmically. It involves a certain exercise of intellectual judgment. Generating and evaluating ideas about social life requires scholarly judgment. I should say that the focus of these remarks is the kind of factual, descriptive, but also normative claims about social life that are part of law schools and also part of political philosophy and my other home discipline and related areas of the humanities and social science. The third building block of my argument is that intersecting lines of psychological and sociological research demonstrate that conditions of ideological orthodoxy distort judgments of both fact and value, and indeed distort the capacity to make judgments of fact and value. This is research that has to do with cognitive dissonance, political identity formation, and above all, groupthink, research done by Jonathan Haidt and Cass Sunstein and others. I'll try to summarize it very briefly. But it follows, given these three premises, I think, that political orthodoxy leads to a distorted judgments of both fact and value and a distorted capacity to make judgments of fact and value. And the further conclusion that because these psychological effects go to the very faculty of judgment, they undermine the capacity of scholars working in conditions of political orthodoxy to see their own deficiencies, in their judgment. So it's a false consciousness argument. I'm trying to venture a false consciousness argument in the sort of grand Marxist and Freudian tradition of such arguments. So I'd like to start with the claim that reasoning about social life depends on a certain kind of scholarly judgment. I mean, it might not seem true. Aren't some questions purely factual? I mean, does raising the minimum wage increase unemployment? A question like that might seem purely empirical, and a competent methodology might remove all need for a fair-minded researcher in the way Erwin was referring to with his research assistant or student. I didn't catch it. I don't want to deny this possibility. There are questions of bare fact whose answer is just a matter of competent methodology, but there are fewer of them than it might seem. I mean, consider a very incomplete taxonomy of the claims or theories that make up scholarship about social life. There are some bare questions of fact, was the light red or green, which are essentially perceptual or causal. And there are some bare normative questions. For example, should the poor have a greater degree of social wealth? But a great many questions of fact are multi-layered or complex. They really involve descriptive theories that combine a set of individual factual judgments. For example, is climate change well supported, or is the human role in climate change well supported? Is the evidence sufficient? Or will raising the minimum wage increase the wealth of the poor on balance, taking into account both employment effects and wage effects? A great many questions, furthermore, are both factual and normative. They're mixed. I mean, climate change, the climate change example I just gave is in fact an example. What it means for evidence for the claims of climate change to be well supported is a question of epistemic norms. I mean, it's not political norms, it's epistemic norms, but it's still normative. And other questions are more fully mixed. I mean, does statement X count as harassment? Does statement Y count as an instance of racism? Is explanation Z a plausible explanation for why groups tend to behave in certain ways? These are like the mens rea questions presented to jurors in criminal trials. You know, did the defendant intend the victim's death? Did the even more obviously, did the defendant act with malice? I mean, these are mixed questions of normativity and factuality. Above all, complex interpretive judgments tend to involve mixed considerations of fact and value and complex multi-layered considerations of fact and value. I think in legal academia, we tend to overemphasize the normative descriptive division as if it were a wall of separation. But in fact, that view of the distinction has been on the retreat in philosophy from whence it came for about 70 years now. The separation between normative and descriptive statements is more like the separation between two rivers that occasionally join together and separate, and less like a wall of separation. So take some examples from my own field of criminal theory. One of the great questions of the field is, why is European criminal punishment so much milder than American criminal punishment? In my work on the subject, I have counted 12 major explanations in the literature. One line of explanation focuses on European fascism. The idea is that making criminal law more humane was a result of Europe's experience with oppressive totalitarian regimes. Another major explanation is about racism. Per Michelle Alexander, what has changed since the collapse of Jim Crow is that it is no longer socially permissible to use race explicitly as a justification for discrimination, and thus we substitute criminal punishment. A third explanation is about crime rates. The phrase in the literature is that there's been a hurricane of crime in the 50 years in which we saw the rise of American criminal punishment. Fourth explanation has to do with American populism versus Europe's more insulated criminal justice bureaucracies. Fifth explanation has to do with America's heterogeneity versus Europe's relative homogeneity. A sixth explanation has to do with American individualism versus European collectivism. I could go on. There are 12 of them. They're actually all pretty plausible, and there's some evidence to support all of them. None of them involves a bare claim of fact of the is the light red or green variety. They involve complex, multi-layered interpretations of facts, descriptive theories, which intermingle both complex bodies of factual judgments and evaluations of evidence and various epistemic normative judgments, but also various kind of more political normativity as well. They're profoundly inflected by values. And so my point is this. The scholarly enterprise, at least among those of us who study the social world, is an enterprise of judgment. Scholars do not just conduct methodologically competent experiments and report their findings. They exercise both factual and normative judgment, and often the two are mixed. So with that in place, let me turn now to the second part of my argument, which has to do with the body of research about groupthink and tribal politics. The basic finding of this research is that like-minded individuals act like a giant amplification chamber. Get a bunch of like-minded individuals in a room together, or a group of people who, due to some orthodoxy, say like-minded things, and they will tend to make one another both more extreme and more confident in their extremes, in their views. That is, they will distort judgments of both fact and value, and they will push each other from moderation towards radicalism. So the factual research on this is among the more astonishing findings in modern social science. You know, it's not surprising that peer pressure may influence our judgments of value, but our judgments of bare fact, I mean, really? In a famous experiment, the Ash experiment, subjects were presented with simple lines drawn on paper and asked to identify which lines were of the same length. Some subjects were placed in groups with people who, unbeknownst to the subjects, had already agreed to choose the wrong lines, to say falsely, this line is the same length as that line or the opposite. Those not in the groups chose the correct line 99% of the time. Those in the groups with the plants repeatedly chose the wrong lines, repeatedly asserted and really believed that the lines were of the same or different lengths when they were not. Those effects become stronger when the factual judgments involved are compound or descriptive. So one experiment involved putting together a group of moderate climate change skeptics, people who weren't sure, but they didn't really think climate change was everything it said to be. Give them a few hours to discuss, and they will come out very confident that climate change is a hoax. In other words, they come out with two new features from their discussion. Their views are more extreme and they are more confident in them. And the opposite is also true. Take a group of people who think climate change is a serious problem, put them together, and in a few hours you get this result that they think it's the greatest emergency facing the world and they're certain of it. All this is not only, it's true of bare factual judgments, it's doubly true of compound or descriptive theoretical judgments. It is even more true of value judgments. So this form of distortionary groupthink manifests both with respect to judgments of fact and judgments of value. If you get in one study, a group of left-leaning people were asked about both their views and their confidence in them on a survey. Those people sat in groups with like-minded individuals and discussed their views, and then they took the same survey and they registered more extreme views and higher degrees of confidence afterwards. And again, the same on the right side. The opposite is also the case. When you put people in diverse groups, that is, groups with diverse views, they tend to moderate each other's views. They tend to come out of it less confident in their views and more moderate in them. This has led to what Cass Sunstein calls the iron rule of empirical research into judicial behavior. If you've got a panel of judges and, say, two are Reagan appointees, or say all three are Reagan appointees, or let's assume that correlates with being more conservative, being together with two other people of the same persuasion will move all three farther to the right. Group of Carter or Clinton or Obama appointees, all three will move farther to the left. Put them together on a panel with two Reagan and one Obama appointee or some combination thereof, and they will tend to moderate one another. And that isn't just true when they issue a joint opinion, where they're to some extent moderating because they're trying to keep the third vote. Even when there's a dissent, the two people writing for the majority, the two Reagan appointees or the two Obama appointees, will still be more moderate. That is, their views are influenced by the very presence of the dissenting individual. The research I've cited thus far focuses on perceptions of fact and perceptions of value, but a second line of research is about cognitive dissonance and incentives. When you're within a unified political community, when you're operating within a political orthodoxy, you win praise for upholding the orthodoxy and censure for denying the orthodoxy, and people respond to those incentives. Furthermore, they don't just respond behaviorally to the incentives. One of the most well-supported findings, I'm quoting David Lubin, one of the most well-supported findings of the last 70 years in empirical psychology is that people modify their judgments to fit their behavior. The phenomenon is called cognitive dissonance. It's just very hard to sustain a positive self-image when you're behaving in a way you yourself think is wrong or false, bad. And so when people win praise, when they're in an incentive context in which they win praise for affirming a certain orthodoxy, they will do so because it's in their incentives, and then they will modify their views to correspond to the orthodoxy they're affirming. So the point is this: being part of a like-minded community, an orthodoxy, has predictable effects. It bends and distorts judgments of fact and value in a certain direction, the direction of the orthodoxy, and it distorts the faculty of judgment with which we make our scholarly determinations. Now, those group effects are not always a bad thing. It depends on the social function of the group you're a part of. It might be distracting to the project of faith to have atheists in church with you on Sunday. It might be demoralizing to an army at war to have sympathizers with the enemy in your ranks when you're in conflict. In other words, issues of tribal partisanship, it's not enough just to point them out. One has to think about the social function of the institution in question in order to determine whether they're a positive or a negative thing. But we've already, at least I've already tried to propose something about the function of the university. The function is to produce and evaluate ideas. It's to exhibit the virtues of scholarly rigor. And that virtue, the virtue of scholarly rigor, is undermined by the existence of these political orthodoxies that have such a distortionary effect. So what we have here is thus a mismatch between the social project of the university and the existence of a political orthodoxy. It's just impossible to perceive the world well in conditions of political orthodoxy. It's good for church, it's good for war, it's not good for scholarship. So let me return to my 12 theories as to why European punishment is milder than American. Imagine you've been surrounded for 15 years by people who are obsessed with fascism, and they talk about fascism all the time. That explanation that the difference in European and American criminal punishment turns on fascism would come to seem true. But it only comes to seem true because you've been in such a social community for so long. That's the fundamental opposition between orthodoxy and rigor. Orthodoxy creates social conditions in which rigor is unsustainable. Every claim arising from such a community comes with a small asterisk that implicitly reads, this claim comes from a community whose orthodoxies make claims of this form seem plausible. I'm being signaled that my time is up. Let me just very quickly note the last sort of tail to the argument. It's a false consciousness tail. Insofar as one is part of an ideologically unified community, one will be unable to see one's own distortions. That's the false consciousness. So return to some of my earlier examples. Does statement X count as a racist statement? Well, if you're part of one of these communities, it will seem that it does, or it will seem that it does not. It will genuinely seem so. In all good faith, you will think it's so, but you only think it's so because you're relying on a faculty of judgment which is infirm because that faculty has been formed by a political orthodoxy. Is why a plausible explanation for why European criminal punishment is so much milder than American. Again, the faculty on which we rely on making that judgment is a distorted or damaged faculty because of the social community of which we're a part. Explanations which seem plausible, really seem plausible, and yet be an illusion. Now, false consciousness arguments are always a little bit disturbing, even offensive. They say to people that their views as to what they believe are not that which they really believe or would believe if they were in less indoctrinating conditions. But for false consciousness arguments to be disturbing or even offensive doesn't make them false. And so what I'm ultimately proposing is that insofar, and again it's a stipulation for purposes of the argument, insofar as universities foster political orthodoxy, they undermine, they create a false consciousness where claims will seem true that are not. Thank you.
Will? Thanks. So rarely do I feel like my position on a panel is the resident pessimist, but I may actually be among these. I feel like actually I have a lot of agreement. I think it's good that we all seem to think that false orthodoxy is bad, scholarly rigor is good, and universities should do something about that. But I guess I worry I may be the most pessimistic one here. So let me articulate my pessimism and then the best I can do. So, unlike Erwin, I guess I do worry that the current situation in universities, and especially law schools, does have a scholarly rigor problem and an intellectual orthodoxy problem. I think I agree, sort of part of where this comes from, the difficulty he pointed out, and I agree, is that a lot of good scholarship has a normative component, and a lot of normative arguments have important assumptions. And I think even when people are working in very, very good faith, I think it's very hard to analyze those assumptions in a way that's rigorous and fair. So I think it's good. I think the problem is not so much among the very best arguments or the very best scholarship. I think a lot of us can agree that democracy and distrust is both wrong and very good. And I'm not so worried about John Hardy Lee or Alexander Bickel. But I think the real problem is one that happens say one level of quality down from that, which I think is where most scholars are myself included, are going to reside. So if your argument is not as brilliant, but has sort of a more substantial whole, so most scholarship that makes a real contribution often will still have to rest on a quite controversial assumption that you just have to sort of accept and move on to get anywhere. And I think people find it, without even thinking about it, much easier to swallow or at least tolerate those assumptions when they're ones that they themselves find plausible. And I think I've seen this in workshops and job talks at various institutions I've been around. I think if you give a talk in criminal procedure whose premise is that over-incarceration and over-criminalization is a problem, and that you have some solution about how to solve that, I think many people will say, okay, I understand that the premise is controversial, but I can accept that and move on to the paper. If you try to give a paper whose premise is that we don't have enough criminalization, enough incarceration, and you're just going to take that as a given and tell people how you can throw more people in jail, I think many people will just say, whoa, that's a big thing you're asking me to swallow, and the whole project is kind of misconceived by that assumption. And that may be right, which of the assumptions is right, but I think we see that kind of double standard happen a lot. And again, I think it happens the most with work that really does have a whole, but most work does. So I worry less about the brilliant scholars who are unorthodox. The brilliant unorthodox scholars will be fine. And there may even be a demand for them. I think there is enough demand for intellectual diversity, enough recognition of that the really brilliant unorthodox scholar may actually may do very well. But the many, as I said, the many of us who are more flawed, I think have to worry more about how to handle that kind of problem. And I'm worried about that. And then I also worry that tenure is not enough of an answer to that problem. So tenure is good. No law school should get rid of tenure, especially not mine. But many of the sort of sanctions and pressures that I think scholarship faces these days are at a level other than the possibility of losing your job. So lots of professors who are my friends, and worry about, they want something more than what they have. They might want public prominence of some kind. They're trying to get a book contract, or they're trying to get a public job, or they're trying to get a job at another law school, or they're trying to get more people to join their intellectual cause of whatever kind it is. And none of them are immune to the kind of pressure that comes with the possibility of some sort of reprisal if they say something untoward. At some schools, the administration might have softer power to move people to classes they don't want to be moved to, or take them away from something else they don't want to have, or just even if administration doesn't do that. I think I was just talking to a friend who has some important and controversial ideas that he's not going to write about because it's just not worth the hassle. It will just, even if it's just a matter of students complaining and becoming vilified in a post on a popular legal blog, it's just not worth the hassle. I think those kinds of pressures are a real threat to scholarly rigor and threaten to impose an intellectual orthodoxy, and are ones we ought to try to find a way to combat, that even if they come, from somewhere else. Another reason I'm pessimistic is, so I think that the best antidote, and what I'd like to be able to say, is that as long as we all agree to praise sort of the standards of scholarly rigor, and that if you follow the methods of our discipline, like if you're a really good physicist, that's what matters. And I think that works for a lot of disciplines. I think it is a difficult thing to make work in law. And I think I'd like to see it be made to work, but I think it's difficult because there's so much disagreement at this point about what even counts as rigorous and good legal work. So I think one thing that helps, and that Dean O'Connor would have talked about if she were here, is the use of other methodologies. So I think law and economics, law and history, a range of other methodologies have gotten a real success against these kinds of threats by being able to say, look, we're rigorous. We used a large data set, and our regressions are very good, and we've controlled for everything you're supposed to control for, and you can kind of prove controversial things in the field of law and economics through the use of a kind of other well-established discipline. I think that's true. It's true for a lot of disciplines that have been borrowed, political science, et cetera. But not every legal question is a question of economics or a question of history or a question of philosophy or a question of some other discipline. Some of them are really questions of law. Like law has its own standards and its own methodology. So you can't just solve the problem of scholarly rigor by eliminating the field of law and parceling it all out to other departments and disciplines, although I know people who would like to. The next possibility that I think helps a little bit is that, since law is performed by courts and government agencies, you can use that as an external source, right? The person whose ideas are being taken seriously by the Supreme Court, or the person whose ideas have been vindicated by those who have legal authority. Maybe that's a sign of rigor. But that, I think, risks confusing law and politics. And I think there are things that, legal ideas that are true, even if the Supreme Court doesn't think they're true. And hopefully an important function of the Academy is to talk about those ideas and not just be an adjunct to the Supreme Court or an adjunct to things that are in power. So I don't know that totally works either. And it would work if we had, sort of as a field, just collective standards of what counts as a good legal argument. But I fear we don't. So people say that you don't want any astrologists in physics departments, and that seems right. I will say, I have friends and even colleagues who have described me as an astrologist, who say, I think originalism is no more legitimate and has no more intellectual integrity in constitutional interpretation than astrology does. Now, I'm pleased to say, as far as I know, they're happy to have me as a colleague and vice versa. But that makes me think the astrology standard is actually a dangerous one. That I think we may not, in law, even be at the point where we can agree on which methods are astrology and which ones aren't. And that makes me very nervous about the possibility of a pure sort of scholarly rigor approach to solve them. So I'm not sure what to do about that. One possibility, and I do think there is something to it, is the framework of intellectual diversity. Not as a first best. I actually think as a first best way of thinking about how to organize an academic department, you wouldn't say intellectual diversity is important. You'd say, no, rigor and scholarly value is important. But maybe as a second best, when we're in a situation where we don't yet know what's astrology and what's physics, then maybe the second best is to try to have at least some of the putative astrologists from each major camp around. The hope that over time we can work it out and we can have people who can break up the kinds of orthodoxies that Josh is talking about. Maybe that's a good sort of second best way to do this. I'm not totally comfortable with it, but I'm not sure I have a better idea. The other possibility I've been thinking about is there may be a few ways we can have at least some basic norms that don't yet rise to the level of having worked out what is law. But that can help sort of fight against some of the ideas I was talking about at the beginning. One is to avoid what some writers have called isolated demands for rigor. So rigor is good. Isolated demands for rigor are bad. That is to say, when you're faced with an argument you don't like, you nitpick every premise and every sort of unproven step in the argument and say, look, it just wasn't very good work because after all, do we really know that this premise is true, or do we really know, what about this, what about this, what about this? When the same arguments might be able to be applied to something on your own, something you find more congenial. So I think to at least try to have a norm that whatever the standard for rigor is, whatever kind of premises have to be proven or not, ought to be ones that we don't only drag out when it's an idea that we disagree with, but apply equally to ideas whether we agree with them or not. Second norm is to avoid intellectual taboos, which I think is a slightly stronger and different principle than just free speech. I think in lots of places, including lots of law schools, you end up not with an actual sanction if you say sort of certain disapproved ideas. I think that we're very healthy on that. But more of a kind of collective social sense that there are certain topics that are just better not raised or better not talked about, or that are taboo. And I think it's hard ultimately for a law school to survive, or for an intellectual enterprise to survive, if you have very many intellectual taboos. Maybe you can survive with a few. Maybe we have a couple and we can live with that. But I think we have to be very, very worried about intellectual taboos, because that creates a kind of a dark space where the orthodoxies can develop and all sorts of things can be suppressed. My last thought, and maybe this is the right gathering which should say this, is less about kind of in general how should we structure law schools, and more about how should those who are unorthodox behave? So we're talking a lot about political orthodoxy, how to, but suppose you are somebody with ideas you know to be unorthodox, whether that's a controversial interpretive idea or a political idea or a normative approach in criminal law that most people disagree with. What should you do? I think there are two useful things here. So one is, and the thoughts about Free Speech Week reminded me of this. I think it may be especially important in that context not to be, both not to be afraid of being provocative, but not to be provocative just for provocativeness' sake. So it's one thing, and this is a campus point, it's one thing for a student group to invite Charles Murray because they think he has important things to say and they are willing to, the fact that he's controversial shouldn't be a minus. It's something else to invite him because you don't actually care whether he has important things to say, but you know that he might get attacked by rioters and you really want to sort of own the left or create some sort of controversy just to stir up trouble. I think it's really especially important for those with unorthodox ideas to avoid doing the latter. I think that taxes the tolerance of unorthodox ideas in a way that's unhealthy and that sort of, could lead to very bad places. I guess a different way of putting that, this way of thinking about it as a scholar, is I think if you are a scholar with unorthodox ideas, with ideas that challenge certain aspects of the orthodoxy, there is a double standard. There will always be a double standard for unorthodox ideas. I don't think there's a way to avoid that. There will be isolated demands for rigor. There will be more people who have more skepticism but more steps in the argument. And I think people who have unorthodox ideas have to accept that. They don't have to think it's okay, and they should hope that over time it changes. But I think you have to be prepared to, in a way, meet a higher standard for rigor, regardless of whether that's fair or not. And that's the healthiest thing for the development of ideas.
Thank you very much. So what I'm going to do is I'm going to ask a question of each of the panelists, different questions, and then in your remarks, please feel free to respond to the comments of the other ones. And so I'll begin with you, Erwin, which, you tell a very rosy story of how the university is doing with regards to sort of this idea of intellectual orthodoxy. And I question that. And I'm going to question that. Obviously you're a dean and you've been on multiple faculties, but having been a law professor now, it's hard to believe, but this is my 17th year. That I've been on a faculty, and the dynamics of let's hire certain ethnic groups or certain genders, and it seems to me that ideological diversity is rarely in the mix, and so I'm just wondering if that accords to your impression, and to what extent that you've sort of made it, how you've addressed that as a dean. And my second question to you, so this is actually based on my own personal experience. So when I was in my mid-30s, 2005, I had a visit at Columbia, and I had to decide what to present as my job talk paper, and I had a couple of ideas. One was something that I was working on with regards to foreign relations law in the Civil War, and the prize cases in particular. But the one I ended up presenting was sort of an article about the Alien Tort Statute, where I told a story. So this was 2000, 2004, 2005. So at the time, the Alien Tort Statute was known as a human rights statute. And I had done research that indicated that it was actually a national security statute. The United States wasn't particularly interested in human rights in 1789. They had other reasons to enact this particular statute. And I remember delivering that job talk paper to a very hostile audience at Columbia that included Lou Henkin, Jerry Newman, Sarah Cleveland, a lot of people who are sort of associated with the idea of the Alien Tort Statute as a human rights statute. And I reflect back upon that, and I'm not somebody that has strong ideological preferences one way or the other, but I pretty clearly think that that was a mistake, right? That I should have presented the prize cases paper that didn't take as strong a normative position, well, strike that, not a normative position, but that wasn't as provocative, or that I felt, even though it was a very rigorous piece of research, that the orthodoxy wasn't quite ready to grapple with. Now we've sort of reached the point where the Alien Tort Statute is no longer, essentially we've gotten to the point where the human rights vision of it has faltered due to recent Supreme Court decisions. And I wonder, Erwin, what your advice would be to a young me or to a young scholar faced with that kind of choice? Because I think that your account of a relatively rosy faculty atmosphere doesn't seem to accord, at least to my impression, with one that doesn't have certain visions of what intellectual orthodoxy are in legal scholarship.
Yeah, I wasn't clear then. I'm less trying to describe a rosy story and much more talking about what we should aspire to as law schools. That we should aspire to be places where there's free speech, where there's intellectual diversity, and there's intellectual rigor. That doesn't mean that law schools are achieving those goals. It does mean that this is what we should try to achieve. You asked me specifically about my experience as a dean and a faculty member on faculty appointments committees. And I think I've been part of faculty appointments committees at least 4 different law schools. And I believe that intellectual diversity should be a factor in hiring, just as I believe that racial and ethnic diversity should be a factor in hiring, that if it's necessary in order to achieve gender diversity, that should be a factor in hiring as well. I do think that what I have found is it's often difficult because in the vast majority of instances, I don't have any way of knowing what the ideology of somebody is. But I've been part of conversations on faculty appointments committees as recently as last month where it said, you know, this person would add to intellectual diversity as a positive to be considered. In terms of my advice to a young scholar, obviously it would depend on context and situation, but I understand that if you go to present something that goes against what many people on the faculty believe, it's going to be less likely for them to admire it and praise it and to want to hire you than if you do something that's less controversial. I don't think that's inconsistent with what I'm saying in terms of what schools should aspire to. I wish it weren't that way, but of course it is. In terms of, you said respond briefly to others, I think, Josh, what I'm not sure I understand is what you mean by orthodoxy. I think that word is doing a tremendous amount of work in your argument, and there's obviously a negative connotation to it. And I wonder if you give enough weight to, as a counter pressure, the desire of an academic to make a name for himself or herself. There's a tremendous amount published, and I agree with what Will says. People want to advance themselves, if not within their own institution, going to other institutions, or politically. One way you advance yourself is by saying things that others haven't said. Sometimes that means going further out in the extreme than others have. And a community isn't isolated to that law school. We all are part of multiple communities and desire to be part of multiple communities. So just looking within the one community's orthodoxy may not be enough. And I guess, Will, my response to you is the same as I was saying a moment ago. I think it is often difficult for people to separate their ideology from their evaluation, especially with regard to the less brilliant work. But I think that's what we should be aspiring to do. Certainly when I grade exams, I aspire to evaluate them without any respect to the ideology that expressed. When I'm looking at faculty candidates or looking at people for tenure promotion, I don't want to be looking at ideology. And I think if we commit ourselves to not doing it, we're much more likely to get to where we want to be. I also agree with you that tenure is not enough, but that to me is the difference between a necessary and a sufficient condition. I think tenure is necessary in order to be able to combat orthodoxy, in order to be able to have innovative scholarship. That doesn't mean it's sufficient to be able to do so. And finally, the only thing I want to say is you talk about this disagreement in terms of what's quality. That's inevitable, but that's what we should be talking about. We can have a discussion, even if we disagree ideologically, about whether something is a good law review article. We can also have a discussion about what do we mean by a good law review and our criteria, but that's where the conversation should be and what we should be talking about.
So for Josh, I was really attracted by your framing of the basic issue as intellectual orthodoxy against scholarly rigor as opposed to diversity or the First Amendment, which is why I was somewhat puzzled as you spoke and you sort of relayed this causal mechanism of groupthink and false consciousness that develops in this sort of amplification effect. And the thought that struck me is, you know, don't you end up at the point where you say that the cure really is intellectual diversity, so that you avoid the causal mechanism of groupthink and reinforcement of the beliefs of a particular group that's constant in a faculty. And so I guess the question for you is, to what extent is the solution or the remedy that you see attainable without intellectual diversity? What analytical traction is there to the concept of rigor as you've sort of captured in your original formulation, if really it's this groupthink that's causing this degradation from rigor?
I mean, that's interesting. I'd like to, if I could, respond to that and some of Erwin's remarks, which were interesting as well. I was sort of, as I said, this argument is sort of a trial balloon. I'm trying out this false consciousness argument. And I do wonder if I've written a brief for intellectual diversity, which would imply revising some of my opening remarks to say, you know, the taxonomy, the opposition or antipode isn't between, isn't centered on free speech, but is centered on intellectual diversity. I guess what I've come to think is that political orthodoxy, and I'll try to say a word in response to Erwin about what I mean by that in a moment, but political orthodoxy is indeed problematic for scholarly rigor, and so breaking up those political orthodoxies by political diversity is a good thing. So let me give an example. I think that, you know, Will was remarking that some of his colleagues think that originalism is a kind of astrology. They think that this kind of legalistic, more formalistic mode of legal analysis is just a great mistake, wrong-headed mistake. Imagine a faculty filled with originalists, where that itself is the orthodoxy, and people who make more consequentialist or more realist arguments are themselves sort of silenced by social pressure. I am confident, based on this research, that faculty will become one in which the originalist arguments become inferior. They go unquestioned, their premises become unquestioned, and so on. It just seems to be a predictable social phenomenon that these ideologically unified groups can't maintain scholarly rigor. They can't ask the necessary questions of themselves or one another. And so, you know, I come tentatively to the conclusion that diversity, meaning diversity where that breaks up those sorts of orthodoxies, is a necessary part of maintaining the enterprise of scholarly rigor. With that in mind, let me just respond to Erwin. I want to make 2 points. One has to do with the definition of orthodoxy. It is indeed doing a lot of work in my argument, and I haven't really defined it. I simply mean an atmosphere, a cultural atmosphere, in which formally or informally there are sanctions for disagreeing with dominant views with respect to a topic of inquiry. Right? It has to, in other words, I'm trying to define orthodoxy in such a way that it's related to these phenomena of groupthink and cognitive dissonance. And orthodoxy is anything which would tend to unify people in ways that give rise to these amplification chambers of political orthodoxy. So, excuse me, of groupthink. So if you're engaged, I'm writing an article right now called "The Case for Prosecutor-Public Defender Merger," in which I argue that the two offices should be collapsed, that people should just be criminal justice attorneys for the state. And a great deal of the argument turns on this research about groupthink. It turns out when you get a bunch of prosecutors together, they make each other more punitive. When you get a bunch of criminal defense attorneys together, they make each other more lenient. And those are predictable effects of this groupthink phenomenon. So within a prosecutorial office, I would say that the punitiveness is an orthodoxy. Within the criminal defense bar, I would say the leniency is an orthodoxy for those same reasons. I want to make one more kind of provocateur response to Erwin's remarks. The perception, the aspirations I can't deny, and I admire your leadership with respect to them. But the perception that law schools, that law professors can evaluate scholarship fairly is based on false consciousness. The perception that we are doing it well, this, you know, you sit down on a committee and you say, I think this is a good article because of this, this, and this. Somebody else says this, and at the end of it, you feel like you've done your duty. The false consciousness I'm pointing to infects that very process and perception. So one's own, I mean, even that remark Erwin made, if we commit ourselves to not evaluating in an ideological way, we will be less likely to evaluate it in an ideological way. It was carefully phrased, less likely makes it true. But unlikely, if the word had been unlikely to, no, that's not true, because the false consciousness phenomenon makes it such that even if we commit ourselves to not judging one another on ideologically grounds, we cannot accomplish it because our perception that we are being fair-minded is itself an infected perception. That's the provocative remark. Thank you.
I'll respond when it's my turn.
Sure.
So Will, and this is sort of a question that I could have asked to any of you, and it really relates to how you define scholarly rigor, or how we should define scholarly rigor as legal academics. So, you know, part of me, for the past 3 years, I've re-engaged in practices of counsel, and I've been struck by a couple of things. One is the extent to which law professors and what we do and write research about has very little valence or relevance to the actual practice of law, right? I wish somebody had told me that so much of my time would be devoted to getting business and chasing down bills and the various types of legal issues that actually happen when you're in practice. And I mean, that's more about the practice of law in terms of the nuts and bolts of it. But let's talk about the substantive practice. And it seems to me that the legal academy has moved very much away from the model where the junior academic got credit for writing a treatise or a casebook or doing a tour de raison of the doctrine in a field and really getting a foundational understanding of real law, and then proceeding to more 10,000 foot, 20,000 foot, 30,000 foot scholarship that really seeks to change the world. And it seems to me, you know, whenever I'm in these hiring committees and meetings, which I've done for a while now, I always try to argue for the person with significant practice experience or someone who has actually been out there. And they rarely ever get through. And it seems the young kids that do, or strike that, not the young kids, but the younger job candidates that make it through are the ones that are really swinging for the fences and going for home runs 2 or 3 years out of law school and trying to come up with the big idea that will change the world, and are very adept at writing for the second and third year editors on the student law reviews. They have very clever ideas that the introductions are marvelous, and then you scratch beneath the surface of the paper, and it's not so great, but that doesn't matter. And so, to some extent, I mean, I guess this is sort of this is a different aspect of Erwin's point, where he says, like, well, and I absolutely agree with this too, and Josh was somewhat responsive to this, the point being that essentially legal scholarship is inherently more normative than descriptive, as is the aspiration, for example, in the social sciences. And I guess, like, you know, is that the right conception of rigor, sort of this self-defined identification of brilliant scholarship, like an idea that really is revolutionary or changes the ball? I guess it's not, my reaction is it's not something that scholars shouldn't aspire to. It's just that basically it comes over time. It's not something that a starting scholar should aspire to, and maybe part of this problem is we don't, in the legal academy, spend enough time trying to understand or try to recruit people who develop a breadth of knowledge, rather than this attempt to come up with you know, the metaphor I like to use is perfectly constructed model boats in little bottles. They float down streams rather than ships that can actually sail the currents of real law, right? So I guess this is sort of a question about how do you define rigor other than a perfectly constructed, work of scholarship in a sense that's a law review article, right?
Yeah, no, so I'm tempted to agree with everything, although it's self-contradictory. I guess one problem with the boat metaphor, I think, is, again, boats sink or float. So it's easier for us to tell whether it's a good boat or not. You just put it on the river and watch. And I think it's harder for us to agree on, the relevant river and which way is up and which way is down and all those things. We're talking about a legal idea. I mean, again, our test could be, is your idea one that courts will adopt? Let's say that could be the river, but I don't think we want to limit ourselves to that. I think actually, no, that said, I'll also just say, I do think, this is separate from everything I've said, this is just an independent belief I hold, I think doctrinal work is really underrated. I think there's a lot of really good and even deep doctrinal scholarship. I mean, the treatises are also valuable, but I think even sort of at one level of sophistication beyond the treatise, I think actually we probably need more of it. We need more faculties who value it, and we need more people to do it. To think of the earlier question, though, if a young job candidate told me they were thinking of giving a paper on the best way to understand some doctrinal rule of standing law as their job talk paper, I would say that's not a very good job talk paper. You want something more theoretical that is more brilliant, that's swinging for the fences, and is going to impress third-year law review editors. I mean, I tell them all those things. I would feel bad about it. But if I were trying to actually help them, that's what I would do. So I do think that's true, but I think we need to be the change we want to see in the world. In our roles as people who evaluate job candidates or are on appointments committees or whatever else. I do say, that said, I think there's probably too much of people sort of facing these incentives to write whatever, the ship in the bottle. Or I guess Dan Farber once wrote an essay against brilliance about the sort of, which I think is actually, some of the specific examples were not correct, but the overvaluation in the legal academy of the idea that's sort of brilliant but wrong. I think there is something to that. I will say that's not the thing that most worries me, though. And there's an old essay by Frank Easterbrook that almost nobody ever reads about sort of the differences between law professors and judges. And I think he makes a point that's profound, just that for a judge, we really care about the error rate. Like, we want the judges to get the cases right. We don't necessarily want judges to be that creative. Like saying that a judge was like brilliant and creative but often wrong is like really something we worry about. That's William O. Douglas, if I can name names. But in a scholar, it's different because the failure of most scholarly ideas is actually unimportant, right? Intellectual work works through taking the best ideas of yesterday and building upon them tomorrow. So if 100 scholars write 100 articles and 90 of them are wrong, but the 10 good ones provide a useful foundation for the next round of scholarship, that's fine. There's not a miscarriage of justice in sort of a bad article having gotten published in the Harvard Law Review. So I don't worry about it that much on a systemic level, that there's a lot of sort of brilliant and creative and bad scholarship out there. I'd like to see less of it. I'd like to see more workman-like scholarship myself, but it's not the thing that keeps me up at night.
Spoken like a true member of the University of Chicago faculty. I think what you've described is essentially their modus operandi of faculty hiring, right? Like they're going to come up with 10 great ideas, and one of them will actually be the spaghetti that hits the wall. And so, Erwin, do you want to talk about conceptions of about spaghetti or conceptions of rigor and what the standard should be?
Sure. Respond to Josh. We're all human beings, and we should aspire to do the best we can. When we're evaluating student work or faculty work, we should attempt to do so by criteria that are non-ideological. That doesn't mean we're always going to succeed, but it means if we aspire to do it, and I'll go back to the words I said earlier, we're more likely to succeed in doing it. We're less likely to then be using ideology as the basis for evaluation. I'm always skeptical of false consciousness arguments. I worry that what you're doing is equating distortion of perceptions with false consciousness. And those to me aren't the same. All sorts of things distort the way people perceive the world, but that doesn't necessarily mean false consciousness. I just don't ever know how we can know when there's a false consciousness. And it's so easy to attribute that which we don't believe and disagree with as a product of the false consciousness of others. Let me also just say in terms of, I want to agree with Will. I think that doctrinal work is undervalued. I think it's become more undervalued over the last 35 years than it was previously. Obviously, I strongly believe that doing casebooks and treatises should be highly valued. I think it's interesting why it's come to be undervalued, including in the hiring process. And my explanation for what you described is that those who are coming to law teaching from practice are at a tremendous disadvantage in terms of the quality of their scholarship compared to those who come with PhDs or very sophisticated fellowships. And I've seen this over and again, that the people who come to law teaching from great practice experience just don't have the scholarship by all of the criteria of rigor that we talk about that can match up to those who have been doing PhDs. And so that at least at the elite schools, we're much more likely to hiring those who have PhDs or the fellowships that have allowed them to work on it. I don't agree with your premise of there's little valence between what scholars do in the practice of law. And here I'm going to praise Will. There's a case being argued next Wednesday in the Supreme Court, Franchise Tax Board versus Hyatt. Will wrote a terrific article in the University of Virginia Law Review that he then turned into an amicus brief that he co-authored with a professor from Duke, Steve Sachs. If you look at the briefs in that case, both petitioner's brief and respondent's brief, there's tremendous discussion of the ideas that Will put forward. And disclosure, I'm arguing that case for the respondent, but I'm enormously grateful. Will's brief was a brief in support of neither party, and it was denominated a brief in support of neither party. But if you look at how much Will's brief has dominated, even if you look at the blog post on SCOTUS blog yesterday about this case, a great deal of it is focusing on Will's brief and Will's argument. So I think there's a way in which scholars can have an enormous effect in terms of the practice of law.
Well, I think I have to say that this is a very effective litigator's trick, Dean, because I think Will is sort of an exception in being a scholar that makes that kind of impact in practice, right? I mean, it's definitely something to aspire about, but I think that the run of, I mean, it seems to me, at least from my vantage point, that whatever we define as scholarly rigor that results, or whatever the standard is for picking law professors and promoting them and tenuring them, has very little connection to do with how much impact that they have on real world law. In fact, the citation measures don't actually take citations with respect to in cases or briefs into account, and they're just about citations in other law review articles, right? So I think that that's it. Mm-hmm. But anyways. At this point, I don't know if any of the panelists want to say anything further, but I would really like to hear questions from the floor, and please feel free to in the spirit of this exchange, to be completely free about what's on your mind with respect to these important questions. Yes, sir.
We've got a mic for you, sir.
And if you could announce your name and your affiliation before you ask your question.
Will do. I'm Kevin Douglas. Thanks for the panel. It was as good as I hoped it would be. I'm Kevin Douglas. I'm a visiting professor at Scalia Law. My question is to Erwin and Josh, and it kind of builds on Will's pessimism about being able to differentiate between physics and astrology, in a sense that, and I'm just going to put it as kind of like my offering what I consider to be astrology, and asking Josh and Erwin whether or not they'd identify it as such. And specifically because both Josh started off saying something akin to one of the baselines of scholarly rigor is going to be searching for truth. And I think Erwin said that at least one of the things we should be looking for when we're determining whether or not something is rigorous, you listed maybe 3 things, and the one that stood out to me is searching for whether or not the arguments and the analysis are reasonable. Is this a reasoned argument? However, there are tenured faculty in many different departments of many universities, including in some law schools, who believe that both reason and truth are fallacies, and that people who talk about seeking them are really just using them as deceptive tools in order to seek political power. And therefore, truth and reason are impossible to achieve. With that, considering that both of you identify those as like necessary parts of scholarly rigor, would you say someone who rejects the availability of truth or the possibility to engage in reasoning should be barred from a university or law faculty?
You want to take that first? My answer is no, they shouldn't be barred from a law faculty. I think we can debate even those fundamental questions. I don't believe there are true answers to normative questions. But I believe that others can think that there are true answers, maybe because of their religion, maybe because of their moral framework. I think that there should be room in a law school faculty for both of those. I do believe that law is premised on reason, and arguments are key, and we should be able to evaluate arguments. But I'm willing to accept that somebody who would want to say there's no such thing as reason because it's all about false consciousness, that's not your position, but somebody could say that, and I think there's room for that in the academy as well. I think that we should be an academy where all the ideas can be expressed. Now, if somebody takes an idea that's against, it can be criticized for their ideas too. I mean, you know, if somebody wants to say something that's pretty extreme with regard to either of these things, and others can criticize that person, that's fine too. That's part of reasoned discourse.
Yeah, I agree with Erin on this. I think about the members of the Academy in critical legal studies, for example, who have denied the possibility of truth and argued that speech acts, claim making is an act of power, an act of social power, rather than a genuine claim of truth, that it's impossible to have a genuine claim of truth. You know, I associate that position with like Roberto Unger in the Legal Academy, or with the Frankfurt School in critical studies more generally. And I have actually benefited from it so much. I mean, it's fascinating, and they intelligently argue it, and they're great interlocutors. In print, I haven't met most of them. And, you know, I welcome their presence in the Academy. Now, there's something in what you say about the degree to which claims of this form are self-falsifying. After all, someone like Roberto Unger or others of that view say, there's no such thing as truth, all such claims are power. That very claim is, of course, a claim of truth. It is defended by further claims that are reasons and so on. And so there's a term in philosophy, self-referentially incoherent. The claim that there is no truth is self-referentially incoherent. Among the logical positivists of the 1940s and 50s, and to some extent the 60s, one of the great premise was that every meaningful claim about the world must either be empirically verifiable or logically deductive, that it was a way of denigrating normative claims. Someone pointed out that claim itself, the claim that every such claim must be empirically verifiable or logically inferential, that claim itself is neither empirically verifiable nor logically inferential. To no one's surprise, maybe to some people's surprise, the energy did not go out of the movement after someone pointed that out. It just kept right on ticking. So I don't know why self-referential incoherence doesn't embarrass people more. But it doesn't. They just keep right on trucking.
Yes.
Jonathan Adler, Case Western. I have two questions. The first is, I'm wondering whether or not the relative uniqueness of a law school in the academy is important to consider, in the fact that unlike, say, a political science department that is producing political scientists, we're not producing academics or scholars. We're producing and training lawyers to be part of a profession. And should that alter the way we think about law schools and with regard to these questions, as opposed to, say, other parts of the academy? The second question is given this discussion, what should we make of institutions that require some sort of profession of commitment to orthodoxy as a condition of entrance? And the two examples I'm thinking of are certain religious institutions that require a profession of faith, which could certainly bear upon some of the questions that are objects of study, but also certain institutions, including some state institutions, that require statements professing fealty to certain conceptions of diversity and inclusion as part of the appointments process.
Will, do you want to answer that?
Sure, I'll start with the second. So I guess, and I have two answers. They're bad and they're okay. So I think, personally, I'm uncomfortable with those, and I'm happy not to be in an institution that requires any of those things, and I think I'd be very uncomfortable at one that did, even if it were one that I could comfortably make, which I couldn't for a lot of those. So I think that's at odds with the kind of university and intellectual community I want to be a part of. But I'm also a pluralist, so I think, there are relatively few institutions like that, and having a pluralism of different kinds of institutions where this sort of actually relates to the previous question, where some members of the intellectual community have a different set of premises about how the intellectual community should work, is something that's fine. And occasionally we can learn from that. Occasionally we can learn that something really valuable comes out of one of those. Maybe it'll turn out I'm wrong about the premises. So I'd fight against that, any kind of orthodoxy at any school I was a part of. But I also don't think we need a federal law stopping institutions from doing that, or even a sort of real crusade against it.
If I could just add something. To me, it has to do, these creedal commitments that one makes upon entrance, it really has to do with the social function of the institution in question. This relates to my, broader argument. I think it's perfectly appropriate for a church, whose function it is to create an atmosphere of faith, not doubt, to require its leadership to be believers. And I think it's fine to require, members of the military to uphold the U.S. Constitution, swear fealty to the commander-in-chief, that sort of thing. It has to do with the social function. What strikes me as the real mismatch between kind of those sorts of creedal commitments and the orthodoxies they reflect or inspire is the mismatch between those sorts of commitments and the mission of the university, the enterprise of scholarly rigor. That, I think, is the toxic mismatch. I guess it goes to your law school question to some extent. I don't see my argument as, I think there are interesting modifications to these ideas that arise when one thinks about the law school specifically, but really I think making both complex descriptive judgments about the facts of social life and normative judgments about social life is an enterprise that is shared by law schools and other disciplines that study the social world, with disciplines like sociology or political science or economics and so on, philosophy, my own discipline, and my second discipline. And so my argument was meant to be applicable to all such areas of study.
I agree with what they said about the second question. I want to address the first question. I don't think I accept the premise of law schools being unique. What you said was law schools are producing lawyers where political science departments are producing political scientists. Most political science departments are training undergraduates, very few of whom are going to go off to be political scientists, or that's true of undergraduate departments. Also, law is not the only professional school within a university. That a journalism school might be thinking of itself as training journalists, and we can go on with other examples in that regard. I think where the question you raised to me becomes difficult is, what if what law professors are doing is scholarship about training lawyers? Should that count as legal scholarship? This almost goes back to your example of what the law professor is producing is a case book, which is about training future lawyers. Should that count as scholarship? And I think at most universities now, at least elite universities, they're not going to count a case book as scholarship. And is that something that makes sense? But otherwise, I would say the fact that law schools are training lawyers shouldn't affect the kind of things we're looking for in terms of defining what's quality legal scholarship.
In the middle?
I will sit for the benefit of the cameras. Lorianne Updike-Toller, and I'm a fellow at Yale Law School. I wanted to construct a theoretical law school in which students rose up and essentially took over the school for a couple of days and theoretically had a town meeting, and it became clear that there was an orthodoxy among the students that reflected in part an orthodoxy among the faculty. For the hypothetical dean, how would you advise her? And I will be taking notes.
So we'll begin with all the truly hypothetical deans, not the real one.
So, what's the context? Sorry. And this is a hypothetical uprising, not a real. So I guess this actually relates to John's question too. I think there is, I think a piece of this we haven't talked about are like the students as I think a really important part of the law school that I think really do shape a lot of the culture. And I think that's right, that the pressure, the fact that faculty members ultimately have to teach law students something they feel is valuable, and that sort of there's ultimately sort of student demand and student pushback is important and really hard to avoid. I guess I mean, I am only a hypothetical dean and, you know, will never be a real dean. So I don't know that I have a real
Don't
answer.
say never. You never know.
We can try to bind ourselves, even if the. I do think town hall meetings are dangerous, and a lot of the mechanisms Josh has talked about can get replicated at them. I think gathering everybody together makes it really sort of makes the natural pressure actually the sort of assertion and promotion of orthodoxy. I know I have a friend at Duke who said that one of the Duke president's cardinal rules of university administration is never have a town hall meeting. It's just sort of, there's no percentage, it's not a useful way to actually like have debate and dialogue. What ends up happening is a kind of performance of the orthodoxy in order to suppress the unorthodox, and or a few people who are troublemakers who kind of are being, you know, controversial for the wrong reasons. But it's a really hard mechanism in which to have reasoned discourse. I know nothing about this, that seems right to me. So, no town hall meetings.
Yeah, I honestly, I don't know what leadership should do with this turbulent student population we have today, you know. I do agree with Will that, let me maybe add about town hall meetings, and let me add this. In my experience with law schools, even pretty ideologically unified and pretty small law schools, and I think I've spent some time at two law schools of that character, the students aren't really that unified. It's hard to get that much unity out of 200 or so students per class, you know? What the students are really good at is creating such vast social consequences for one another for disagreeing that the 15, 20%, 10% maybe who disagree keep their mouth shut or face the consequences. So what happens at those, you know, at those town hall meetings and other such fora is mainly that pressure is arrayed against dissenters. And that, I think, produces these orthodoxies that inhibit conversation. I mean, inhibit scholarly rigor in the classroom, inhibit in the ideas that the students encounter and the ideas that the professors produce. It really has kind of cascading effects. It's a great source of. So I think, I don't know how this is to be done, but creating a student body, maybe by selecting students so that they will not be so ideologically one-sided, would be one mechanism. Doing the same with faculty and trying to design, you know, Habermas has all these wonderful ideas about how discourse takes place in ideal democratic communities. And I think we could take heed of some of those ideas and say, how do we create discursive communities such that dissenting views can be safely aired? And I think that would be an interesting inquiry, although I don't know how to achieve it.
The problem isn't the town hall. The problem is social media. There's always been pressure within law schools to adhere to a certain orthodoxy, but social media has made it so much more so. So when a student says something that goes against the orthodoxy, the student can get targeted in Facebook groups, the Twitter account, with all of those kinds of things, and I can give examples of it. And I would love suggestions for anyone of how to deal with that. I try to deal with it in my talk to the students at orientation of how important it is to be a place where ideas can be expressed, and if they ridicule others for their ideas, then we don't achieve that. But it doesn't really have any effect. So I don't know the way of dealing with it. And I love suggestions for how a school can deal with that kind of social pressure that I think does exist. I don't think it's realistic that we could select students to achieve ideological diversity. The reality at each of our law schools is the most important thing we look to is LSAT and GPA, because it's 1/4 of our US News ranking, and there's no way around it. I'd also be troubled in terms of, I don't know that we would have measures of ideology. Most students aren't going to tell us their ideology in their essays, and there's always difficulty about accepting and rejecting students based on ideology. I also disagree in terms of a town hall being a bad idea. I do a town hall for students fall and spring, for staff fall and spring, and the reason for that, Will, is to give people a forum where they sense they have a chance to be heard and listened to. There's relatively little occasions where I, as a dean, can let people feel, I'm not talking about faculty here, because faculty do have the occasions to express themselves, but let staff, we do. And I generally find that faculty aren't shy about expressing themselves. Maybe untenured faculty, but for staff and for students, to create a forum where they can come and feel that they can be heard and say what they want. And I have found in 11 years now that it's a constructive thing to do. And the kinds of things that are discussed there generally aren't the kinds of things that lead to, so we're not talking about ideological things. The complaints that staff and students have generally don't relate to the kind of things that we're focusing on now.
Any other, yes?
Hi, Harry First from NYU. I couldn't resist after the last comment thinking, yes, we're back in the 60s. It's great. The answer is clear. Listen to the students. Well, that's the view from the 60s. But I didn't want to ask about that. That was more a comment. And interesting responses because everybody has forgotten they used to be students. My reaction is I love pluralism and diversity. That's my sort of normal instinct. So I'm certainly in sync with what everyone said. It sounds great. And then I thought schools of thought we're familiar with them, right? And we don't seem to condemn those. And they're not diverse. And then I thought, how about the Chicago school? We did have the first program, which this morning, which most of you didn't attend, we talked, and I talked, mentioned a lot about the Chicago school. There's an orthodoxy. Other than its pernicious effect on the law and the world, that's a joke. Other than that, it's been and still is very influential. And it's not known for pluralism. So at the end, I was sort of confused about maybe what the unit of pluralism is. So should we condemn the Chicago school because it isn't pluralistic? Or do we need a theory that takes that into account and says, well, that's okay because... So I'll leave that to the panel, this general question.
So I think because, I think we mentioned this, that it's important to think about these groupthink pluralism problems in the kind of broader context. So I think we often have a productive conference where a bunch of people at the conference share a common premise. So at the American Law and Economics Association, nobody stands up and says, well, wasn't law and economics refuted by Duncan Kennedy or whatever. Not that every criticism is wrong. I think it's helpful for people who do whatever methodology to have thought through those things. But it's also helpful for them to have a space where they can work within a common methodology to advance whatever the ideas are. Or every February in San Diego when originalists gather, to think about working through sort of various ideas about originalism. Although there are originalists and non-originalists and people pushing it in different ways. But I think it's just helpful to say it's important for people who are in whatever that group is to make sure they do face sort of whatever the criticisms are, so that somebody can come along and say, wait a minute, the lines really aren't the same length or whatever the factual challenge is. But as long as there's enough of that happening in the law school and the whatever legal world they're working in, then also having some time and some place a safe space, I guess if I may, in which people can sort of work through a set of common ideas together is really helpful. So I think as long as it's a sufficiently unorthodox idea, it's useful for the people who do it to have a space where they can work it out as orthodoxy.
I guess my only thought in response is that I would need to take a closer look at this psychological and sociological research and how groupthink, the kinds of distortionary blindnesses that it produces, how those happen. I mean, how sustained and singular do the relevant orthodoxies need to be? Here's what I suspect. I suspect that if you spend, half your time in your hometown, which is a small, very religious, very Republican, conservative kind of hometown like mine, and half your time in elite universities that are secular and more left, neither one of those environments becomes quite controlling, and it's only when an environment is quite pervasive that it tends to infect your capacity to form accurate perceptions about the world. In other words, if you're like sometimes in an environment where everybody's saying, no, that line is longer than the other, and you're other times in an environment where other people disagree, you can actually maintain a pretty accurate perception. And that is consistent with Will's point, right? That it's perfectly fine to have a conference where you get together with a group of other crits and you talk about crit ideas, so long as you don't go back to a law school where crit ideas are the only ones that can get a respectful hearing. So it's something about penetration and pervasiveness, and I can't put it exactly. To some extent, putting it exactly would require a deeper dive into the research.
You're much more of an expert on groupthink than I am, but I remember many years ago reading a book called Victims of Groupthink. I think it's by Irving Janis, and it talks about how groupthink affected policy decision-making. And in all of the instances that he talks about, groupthink was a product of a very closed community of people who weren't talking outside of their community about the particular issues. And the more we're part of multiple communities, the less likely it is that there's going to be groupthink. The law school we're part of is one of our communities, but for people, this can be another community. Many other things can be communities as well, that then I think are a way of countering the effects of the groupthink you talk about.
Yeah, if I could give an example to that end, I think groupthink is at least as bad in philosophy as in law schools, because philosophy is closed to most other disciplines or more other disciplines and to the profession. So I got my PhD in Frankfurt from a group of scholars associated with the Frankfurt School, and they're basically all Marxists, and you say something to them like, and I don't mind, they were fun to play with intellectually, but you say something to them like, well, isn't there a flaw in Marxism insofar as the USSR failed, and Vietnam failed, and Cambodia failed, and China failed, and most recently Venezuela has become a disaster, and they say, what are you talking about? They've never heard of such a thing. Like, those objections are just outrageous. Marxist assumptions are just assumptions, and that's a much more frightening, kind of groupthink. That's the closed community that Erwin's referring to.
Yeah. Over there, and then
Hi, Saurabh Vishnu, Texas A&M. I'm interested in your idea, Josh, that the law school, the university, first of all, has a different social function than the church or the military. So I tend to agree with your definition of what the social function of a university is, but it also occurs to me that we could imagine one important purpose aside from the creation of new ideas and the defense and sort of filtering of new ideas is simply the transmission of knowledge, of which there is an increasingly growing body, and the efficient transmission of that to the next generation is at least or perhaps more important than the generation of new ideas. And on the other hand, there is in a law school, there is the function of law and there is the function of school. So is our sort of methodological commitment supposed to be toward the law first, and then to whatever extent there's space for normative play, we go to the fact that we're a university and we're supposed to engage with ideas or transmit them? Or is it first and foremost that we are a university who happens to be tasked with dealing with the content of law? Now, the answer to all of those questions, I suspect you have, and I suspect I might agree with them. But my question to you is, who decides? Because that at least has to be an answer, even if it's normative, to which we need some good, stable consensus if legal education is going to sort of continue. And I'd be interested to know Erwin and Will's thoughts on that as well.
I'm not sure what I think. Would you like to take the first stab at it?
No.
So, I guess I don't know quite how to respond to the who decides question. I was sort of with you up until that last point, and then I thought, oh my gosh, that one I don't have an answer to. Because I am so concerned about the structure of university hiring, for example, departmental hiring or law school hiring, is like a fraternity. It's a group of people who are already insiders deciding who to bring into the club. And because I'm so concerned about false consciousness related to political orthodoxies, infecting our judgments of scholarly quality, this might be point where Erwin and I disagree, but because I'm so concerned about those issues, I am interested in exploring ways of breaking up the club. You know, it's interesting in this regard to think about the Israeli judiciary. The structure of the Israeli judiciary is that I worked for Chief Justice Aaron Barak for a period of time, and was struck Chief Justice Aaron Barak because of both the Israeli Constitution and because of his own personal status. Essentially, he sat on a committee with other members of the judiciary whom he had selected, and they had a controlling vote in all new judges in Israel. There was some input from the Knesset and from the Prime Minister, but it was relatively ineffectual. The controlling decisions were cast by the judges themselves. And so the Israeli judiciary became a fraternity, a club whose members decided on new members, and they essentially collectively took certain positions consistent with their own Barak's views, and all new members had that character. I think that's very unhealthy for the Israeli judiciary and for Israeli society. The American model, whereby entree into the judiciary is partly controlled by the bar, right? I mean, you have to get a degree from law school and establish yourself within the bar, but at the same time, it's affected by outside influences, presidents who answer to voters, senators who answer to voters. I'm really interested in how those structures might be emulated in universities, but I'm not sure about the effectuation.
So I'm not sure about this either, but just a thought. If we're trying to figure out sort of our law schools, you know, law first or schools first, it might be useful for the law schools to have an association of some kind, say an association of all the American law schools who could get together at some kind of conference and maybe have a panel or a series of conversations about that question and sort of like work out amongst themselves what they thought, and then, you know, those norms might be a way to develop them. Here we are.
I can't do better than that answer, but my response to your initial question was yes. Law schools are about the transmission of knowledge about law. Law schools are also about the advancement of ideas concerning law to improve the law into the future. I don't see a tension between those. I think that we have to, as legal educators, be doing both of those things. In terms of who decides, I believe very much in faculty governance. So I believe, contrary to what Josh was saying, it's the faculty that should be deciding who the faculty should be hiring. And I would fight with all of the energy that I have if somebody tried to take away from my faculty the ability to make faculty hiring. Now, it's partially controlled by university review. All of our hires, especially at the tenure level, have to go through a university process. So there's the partly controlled. But I believe very much in faculty governance. But I also don't share your primary concern of orthodoxy as opposed to rigor. So I don't have any problem in believing that the faculty should be the ones who make these decisions.
In the tan.
Todd Zawicki from Scalia Law. As I've been listening to this, I've been thinking about Lindsey Graham's comment at the beginning of the Kavanaugh hearings, which is we will test a great proposition whether somebody can be confirmed to the Supreme Court despite the opposition of 1,400 law professors, which was obviously a joke, right? Because everybody knows that law professors, so many law professors just become such political hacks with respect to those sorts of things, and just kind of brought discredit on the whole profession. But I don't think it's just sort of the public-facing aspect of it, right? It is this orthodoxy problem, right? And I guess what I would ask the panel, one that's puzzled me is the first Obamacare case, right? We got literally hundreds of constitutional law professors in the country, and the half dozen or so who thought the case was not just might be correct on the Commerce Clause issue, but non-frivolous, are basically all in the room right now, right? How could that be, right? I mean, it's like, I mean, the criticism, it was frivolous. It's not an argument even worth taking seriously. And so I guess my question is could it really be that, I mean, is it just that they could be that deluded, right? I mean, is it that the groupthink is so strong that that hundreds of law professors, not a single one who didn't blog for the Volokh conspiracy, could think that it was a non-frivolous case? Or is it, and I think this is something I haven't really heard about, is it that law professors know the truth, but that the social pressures are so strong. And if you just look at the self-censorship during the Obama administration, right, where nobody ever criticized anything Obama did, and you compare it to the Trump administration, is it a willful sort of circle the wagons because it's our guy, and I'm going to do my little bit to protect it, or do these sorts of things happen really just because the groupthink is so strong? And while I have the floor, I just want to pose one question for Will and raise an issue. You drew the distinction about Milo and Coulter and that sort of thing, and you said, well, maybe that's not when to take your stand. And I want to suggest maybe that's where you do need to take your stand. And I think you're being a bit naive about the left on campus today, which is they want to systematically move in the fences. That if you draw the line at Milo, then the next thing they do is they're going to draw the line to Charles Murray, right? And then once you say, all right, Charles Murray's too radioactive, next they're going to draw the line at Will Baude. I mean, they just want to systematically move in the fences, and I think it's actually quite important that the provocateurs in this environment are given the opportunity to speak on campus simply to protect the Charles Murrays and the people and the Ali Hassania, and these other sort of provocative speakers who become the next target as being unduly provocative, as being too much.
I think I disagree with everything you just said. First, as to the law professors who signed the letter, I don't think that made them political hacks. I'm one of those law professors who signed the letter, and what the letter that was published in the New York Times said was that Brett Kavanaugh showed a stunning lack of judicial temperament. I believe that. I think thousands of law professors do. Second, you're right that there were law professors, including some in this room, who believed that the Affordable Care Act was unconstitutional, and there were hundreds that didn't. Those who believed it was unconstitutional had 4 justices on the Supreme Court who agreed with them. John Roberts agreed with them in part and disagreed with them in part, and 4 who disagreed with them. That doesn't mean that they were right and the other side was wrong. It doesn't mean the other side was right and the other were wrong. That's just who had the votes on the Supreme Court. Third, I think you're wrong in saying that liberals didn't criticize the Obama administration. I'm certainly liberal, and I can give you countless examples. Just on a panel right before this one, I was criticizing how the Obama administration used the Espionage Act to prosecute more journalists than any other president in the history of the Espionage Act. I could give you a long list of things that I said, including in print, criticizing the Espionage Act. Finally, in terms of the left, I'm obviously political liberal, but I've in print and on my campus repeatedly said that Milo Yiannopoulos, Charles Murray, Ann Coulter, and everybody else should have the right to speak on campus. So I think it's dangerous to generalize the left as saying they're against free speech.
I think the one comment I'd make is, you started out by saying that, sort of wondering how is it possible that so many law professors could think that the case against the Affordable Care Act was frivolous when in fact it almost won in the Supreme Court. And I just want to highlight that, setting that example aside, I think we might disagree about it in certain respects that would get into a lot of detail, but the research on groupthink does explain that phenomenon. It is powerful enough to get, thousands and thousands of elite members of British society in the 1930s to believe that there is no possibility of war with Germany, right? That sort of phenomenon where many, many people are profoundly wrong about things which are perceivable is the very thing that this research has the capacity to explain, and the magnitude of the effects is consistent with those sorts of phenomena.
So just on naivete, I think there's a tough empirical question that I don't think I know the answer to about whether free speech norms are something where exercising them makes them stronger or makes them weaker. I think it's possible that the more you exercise it, every time you defend the Nazis in Skokie, that'll create more support for free speech, so it's easier, it pushes the boundary out, and there's a bigger breathing room. But I think it's also possible that sort of society's ultimate tolerance for free speech is something that can run out. and that if you should use it up when you need it. It's there. I mean, it's there as a resource for the really controversial cases when we need it. But if you use it too often, the sad fact is that ultimately it may go away. I'm not sure which one is right, but I think there's a serious argument that if you use it a lot, ultimately you won't have any left. But don't misunderstand my injunction. I think the students want to hear from Milo or whoever else. That's fine. I think my suggestion is just to make sure that you understand, sort of remember the reason for the program. And so, especially given the risk that free speech might be a resource that you can use up, you should be using it for things that are worth it. So you should be using it to invite people who you want to hear from, who you think are important, who you think have good ideas. Maybe that's Milo. Maybe that's somebody so crazier that I haven't even thought of. That's up to somebody other than me. But be doing it for the right reason. Be doing it not just to sort of cause riots or sort of provoke people, but because you actually think it's something important and true.
Thank you. We've reached the end of our 2 hours, which and everyone is still here, and I haven't seen anyone nod off to sleep, which is a credit to the quality of our speakers. Thank you very much. And
Thank you for including me.
It was nice to.
Well, thank you for including me. Yes, you too. Thank you. Great to do this with you. Thank you.
Yeah, right. I
I was
understood it
talking
was
about,
another
yeah,
Kavanaugh
yeah.
thing. Yeah. Yeah.
It's actually really interesting. This discussion is happening right now, and it's some are afraid of the students. Sorry. I was tongue in cheek. I was talking about it.
I understood.
Yeah.
I was slow enough.
No.